Right, the record reflect we are back in session. Parties and counsel are present. Our jurors are not yet present. Counsel indicated you wanted to address something before we brought our jurors in.
Yes, Your Honor. There's a witness here for the defense today by the name of Michael Leonard. He's an attorney in San Diego, and my assumption or my understanding is he's being called to testify regarding the sale of the business. I don't have a problem with him testifying about the sale of the business. He actually prepared a 25-page contract with respect to that, and people don't have any significant objection to that. However, there are multiple exhibits, probably 170 some pages of exhibits that are attached onto the back of that contract that the people have an objection to, and the defense wants to offer those exhibits in along with the testimony. The problem with that is that this particular attorney did not do any due diligence with respect to the contract, did not check out the financials, so I have no idea of the accuracy. He's also indicated that there were two parties that were present when those documents were provided, and he doesn't know about the accuracy of those documents, or he can't even tell us as he sits here today who provided him which particular set of documents. These documents contain multiple layers of hearsay, and so the people have an objection to all of those subsequent documents that defense wants to bring in through this witness, because he can't lay a foundation for any of them.
Well, Your Honor, actually, it's the attorney that drafted the document, the contract, and inside the contract it makes reference to every exhibit that's contained within the contract. That's the contract as its whole. These are not exhibits that I created that also now want to say, oh, let's slip these in. These are the exhibits that we received from the attorney as an understanding as these are the representation between the two parties as to the details of this sale. And so we're offering as those are the details of the understanding between the parties, and that's what they represent. And so any representations that were done within that contract are between the parties. Not that he has to establish they're accurate, it's just that's what they said. And that's what they agreed to in the sale of the business.
Well, the only thing that's relevant is, number one, that Mr. Kavanaugh sold the business and the amount that he received for the sale of the business.
Correct. And included in that is also the coverage of all liabilities too, and he hand wrote out what the liabilities are. And that's also in one of the exhibits inside there.
Well, that's hearsay.
If that's what the term of the sale is, that this is my understanding is these are the liabilities that I have that you're accepting as part of the sale price. Because if I have debts in this amount, you're agreeing to pay these.
This is the same objection that you made to the people, to what you believe the people offering Mr. McStay's computer records of the value of the business.
That would not be accurate because those are different in the respect that they would only be offered to show what the value is. This is showing what the terms of the contract are and what the terms of the sales are.
The objection sustained. The only thing that is objection sustained on hearsay grounds, foundation, as well as relevancy and evidence code 352. The only thing that's relevant is, number one, Kavanaugh sold the business. Number two, how much Kavanaugh received in what the sale price of the business was and how much Kavanaugh received.
And Your Honor, the people have been willing to stipulate to that. I believe this attorney would prefer not to testify, and we are absolutely willing to stipulate to that.
Well, that's up to the defense.
The only issue we have, Your Honor, is there was multiple terms of this sale. Is to say you can only mention the parts that we like, that the people like, the cash part. What about the assumption of debt? Every contract sale, that is a term of the sale price. Is if I'm selling you a business and I say, hey, I have $100,000 that I owe people as the business. I'll buy it, but I'm going to knock the price down to cover that debt. That's what occurred here. So to say we can't bring that information in, then all of a sudden cuts down the benefit to Mr. Kavanaugh.
Well,
because the contract speaks for itself, the terms of it. and it's within the four corners of that contract that we're trying to get in. With having to redact spaces out, it's offered for the sole purpose of establishing what the terms of the contract were.
That's an addendum to the contract, Your Honor, and it's pure hearsay. It's a written out list of things that presumably Mr. Kavanaugh wrote, and it's not actually a part of the 25 pages of the initial contract. It's an addition to it.
It's not an addendum. There are
And
exhibits
all right,
that are marked particularly in the contract, though, saying this total is listed in this exhibit N. This exhibit P lists these details.
The objection sustained on the grounds indicated.
The second thing that we have to address, might as well do it now, is Mr. Beasley is here. The court gave a tentative about playing the video. I addressed that to Mr. Beasley. He sent me back an email, which I forwarded to the people. The reason he did the experiment as he did with the sponges and how much he soaked them is, one, that's consistent with the sheriff's training manual that he still had a copy of from the 90s. He confirmed with the leading expert on blood spatter. Is this still the means that it's done? He goes, yes, you still use the normal kitchen sink as the best representation for a blunt force trauma to a head when there's multiple strikes. And so that is the standard to which everybody does in that field of how you do that experiment.
Well, I would still sustain the objection to the video. I don't think there's an adequate foundation that would represent the amount of blood and blood spatter from a particular blow to the head. Again, comparing a sponge to a skull, the amount of force involved in the blow. So I think there's insufficient foundation.
It's not meant to represent how much blood would leak from the brain. It's the direction and what it would look like from a standpoint of spatter, how it's actually created from impact. During the examination or during the experiment, he purposely reduced each strike for each person by one to say, well, the first hit would be to, cause the blood to flow, and then what impact would happen when you hit a wet surface of that type. And so, we can have Mr. Beasley actually offer testimony, and that'd be the defense's preference that we do that, so we can make a clear record as to what foundation he can offer for the representation of that video, how it was done.
Well, I indicated I'd be willing to allow him to do a 402 hearing on it, but so far you haven't said anything that convinces me to change my initial ruling.
And the other item that we'd like to do, there's a couple of demos that he'd like to do on purpose, just showing what a drip stain, trail stain, just simple thing on a piece of paper.
Yeah, that's fine. I don't have a problem with that. That's just demonstrative.
Correct.
That's
and,
fine.
And if we do 402 on Mr. Beasley, I'd like to do that after our first two witnesses to get them out of here.
Okay.
So we can do them during the break or whatever.
Okay. So are you ready to bring in the jury?
Only question we'd have then is what part of the contract was the court excluding? Because I have it before the court.
Is this it?
Yes.
Well, I'm looking at something that is a total of 199 pages. I'm seeing it for the first time.
Correct.
So, my initial impression is I don't know that the contract itself. Okay, so we have, is there all the evidence? again, I don't know that the contract itself is particularly relevant. Again, I think the relevant information is Kavanaugh represented himself to be the sole owner sold it and received the proceeds in the amount of the sale and proceeds. And I mean, if there's particular terms that you want to bring out,
Well, we would like to do the price, the assumption of death, which is the price, the warranty offered in the document. Those are our main concerns.
okay.
Well, again, the assumption of debt is not part of this contract, Your Honor. Again, that was something that the court just ruled that they were excluding because it's a handwritten document by Dan Kavanaugh that is not a party to this, and it's complete hearsay, and there was no opportunity or due diligence by the attorney that assisted in this document to actually verify that information, and it's hearsay.
The document itself is not hearsay. The
All right,
document
I already
speaks for
ruled
itself.
on that, counsel. I mean, if you want to ask the attorney a general question like, did the parties in the sale price take into consideration any potential debts or liabilities of the business? You can answer yes or no to that.
But we can't talk about what that amount would be.
No. Not based on these exhibits, and not based on that the attorney saying these are the exhibits. If you had an accountant who did an evaluation of the business and said, yes, I've looked at all the books and I've come to conclusion as to what the debts and liabilities are. Assuming there's a foundation for the documents that the accountant's looking at.
Okay? Ned? Just so the record's clear, I think that the defense is being denied their due process right and constitutional right to present evidence in their defense. We have the attorney that drafted a contract for the sale. The contract was received from his office. This was kept in his records as part of the terms of the sale to his client. And I think to deny the actual contract to speak for itself is both the state and federal violation of my client's right to due process.
Okay, I disagree for the reasons indicated. Okay?
Yes?
Are we ready to bring our jurors in?
Yes, one question though. So we can have the witness identify the document and then redact pages out after the fact instead of making the jury wait? Because that's marked as an exhibit. The contract the court was looking at.
Just to identify the contract?
Just to identify the exhibit and then we can pull out whatever's going to the jury later.
It was my understanding the contract wasn't going to the jury at all.
Well, I mean, if you want to mark it, that's fine, and have them identify it, just to indicate, yes, there is a contract, it's not just something I'm saying, there's a real contract, here it is. And then when we discuss the admission of exhibits, we can discuss whether any or all of it would be admissible. That's fine.
Yes. Okay. Then we're ready.
You sure now?
I just want to get the clarifications on those issues just for a technical issue.
Okay, we can bring our jurors in.
We have a return right here, Judge.
Okay. So if anyone comes in with returns, they can, or an arrest warrant, you can bring it up.
Yeah.
But if it's a search warrant, I can't do it when we're in a session.
Okay.
Morning. Morning. Good to see everybody back after the weekend. Hope everyone had a good holiday. Record reflect we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. And defense may call your next witness.
Thank you. Defense calls Officer Jeffrey Adels.
Yes, I do. State your full name, spell it for the record.
It's Officer Jeffrey Adels, A-D-E-L-S, with California Highway Patrol.
And spell your first name, sir?
J-E-F-F-R-E-Y.
If you proceed.
Thank you. Officer Adels, you're employed with California Highway Patrol?
Yes, I am.
For how long?
Approximately 10 years.
And just briefly, can you generally describe what your duties would have been in 2010?
In 2010, as well as today, I still do traffic, write tickets, take traffic collisions, arrest DUI drivers, everything pertaining to the freeways and unincorporated areas.
And in 2010, in February, where did you patrol?
On February 2010 was the 15 freeway in the Cone Pass.
And did you respond on February 6th in that morning to take over an investigation for an accident on the Cajon Pass?
Yes, I did.
And what time did you arrive on scene?
I arrived on the collision scene approximately 0900 hours or 9 a.m.
And what time did a dispatch call first go out for officers to respond to that scene?
There were officers working in the Cajon Pass that day. It was heavy rain, and on this particular collision, it was approximately 07:18 hours.
And could you describe where the accident occurred?
The collision occurred 15 southbound, just north of State Route 138.
South of 138?
Just north of State Route 138.
And I'm going to show you what's been previously marked Exhibit 1060. Do you recognize that exhibit?
Yes, I do.
Did you have a chance to review this exhibit before your testimony?
Yes, I did.
And would that be kind of like an overhead terrain map of the Cajon Pass, the 15 freeway?
Yes, it is.
And in the middle of the page, there appears to be a black dot with a circle with the word collision written to the right of it. Do you recognize that?
Yes.
How do you recognize that writing?
I placed that dot and wrote the collision. It's approximately where this traffic collision took place.
Now that collision, the Cajon Pass has a northbound and a southbound lane, correct?
Yes, that is correct.
And sometimes they're adjacent to each other and sometimes they separate.
Yes.
And you can kind of see that on the map behind you. Would that be accurate?
Yes, it is.
And the location of the accident, was it a place where it's separated or was it adjacent?
The freeways were running adjacent or parallel.
And Was there anything dividing the two the northbound lane and the southbound lane?
Yes, there was a single guardrail.
And the shoulder for each side, let's say shoulder on the southbound side, how wide was it in 2010?
It was approximately 16 to 18 feet.
And when I say shoulder, which shoulder are you describing?
The left shoulder or within the center median.
And can you, without going into too many detail, can you describe basically what kind of accident this was?
This collision was a fatal collision involved, actually, two individuals died at the scene. There was a traffic collision prior to this in which the vehicle spun out and hit the center median guardrail, and now the vehicle was parked in the center median, the wide center median. A tow truck responded to a possible vehicle blocking the number 1 lane of 15 southbound. The tow truck pulled in front of this vehicle to render assistance, and as the driver of the tow truck was exiting his tow truck on the left side, a vehicle broke traction with the roadway in the rain and collided into the right side of a Nissan Altima and then rear-ended the tow truck, causing fatal injuries.
And when you say lost traction, is that where someone just kind of slides because they have no control?
That is correct.
So pretty much there's an accident, someone's driving along, lose control, crash into it, and there's fatality.
Yes, in this case.
And when there's fatalities on the highway, what steps are generally taken by the CHP to deal with that type of investigation for the roadway?
Based on this particular one, there was multiple collisions in the area. Prior to this one, normally there is a roadway closure or lane closure. In this case, the collision was fully contained in the center median, so it was irrelevant to close any of the lanes of 15 southbound.
So since the road wasn't closed, there was still traffic allowed to go north and southbound?
That is correct.
And when you arrived on scene, what was the traffic conditions at the time?
Traffic conditions were light.
So not many looky-loos?
No, they weren't.
And at the time the accident occurred, you were heading into work?
Yes.
And you were driving in the weather that was occurring at the time, probably likely around when the accident occurred?
On this particular day, yes.
And how would you describe the weather in the morning?
Based on what I remember, it was drizzling down here. I do not take the 15 freeway to work.
And is the rain different down the hill versus the Cajon Pass versus up the hill?
Yes, it is.
So what weather we have down the hill where you're driving, not necessarily what represents what's going on in the Cajon Pass?
Correct.
And the Cajon Pass on that day it was heavy rain?
It was heavy rain approximately till 07:30.
And it was causing the unsafe conditions of roadway, wet and slick and flooded?
That is correct.
Do you have a pretty good memory of this date based on doing this investigation?
Yes, I do.
Do you remember the rain conditions around that time, within the day?
When I arrived on scene, the rain had stopped in the Cajon Pass, and then throughout the day, the weather cleared up.
How about the day before? Do you remember?
No, I do not.
How about the following day?
No, I don't.
So would you say it was cleared by late morning, afternoon?
Approximately, I know it was clear down here approximately 11 p.m. or 11 a.m.
And the Cajon Pass was cleared by 9 o'clock when you got there?
Yes, it was.
And do you know what the weather was like up in Victorville?
No, I do not.
You didn't, that wasn't part of your patrol?
No, it isn't.
And after you cleared the scene in Cajon Pass, did you come back down the hill, or did you go, where'd you go?
I came back down the hill to do follow-up at San Bernardino Community Hospital.
And what was the weather when you came down the hill?
It was clear.
So it was drizzle in the morning and clear later in mid-morning or afternoon?
Yes, late morning.
Nothing further. Your Honor?
Yes,
Nothing further.
oh, I'm sorry, okay, Cross?
Briefly. Here, let me freeze this up here real quick. You indicated that the collision was on the southbound side at about 0700, right?
That is correct.
Okay. Looking at Exhibit 1060, your black dot is on the right-hand side of the 15 freeway, correct?
That is correct.
Wouldn't that be the northbound side?
It would be the right shoulder of the northbound side, yes.
But the collision we're talking about is in the center median of the southbound side.
Yes, the dot wasn't placed exactly where the collision occurred.
Okay, so just to make sure we're precise and no one's misled, there's a black marker here. Can you write underneath collision southbound median, please? Wow, you did it literally. I was expecting abbreviations, but we'll take it. I just don't, it's important that we make sure we're accurate in case someone looks at this a week or two from now and doesn't quite recall.
I'd object to the commentary.
Sustained.
Okay, so it's in the southbound median. You said it was contained within the southbound median, correct?
That is correct.
And it did not necessitate any lane closures.
Correct.
Do you recall what time you arrived at, roughly 9 o'clock in the morning, correct?
Yes.
Approximately what time was that collision cleared from the scene?
Approximately 11 to 11:30.
And you said that day was light traffic, correct?
Yes, when I arrived on scene.
Nothing further.
Anything else?
No.
How, Victorville is further north from that location, correct?
Yes, Your Honor.
About how far?
Approximately 15 miles.
Okay. Anything else?
No.
No?
Any objection to Officer Adele's being excused?
Nope.
No, Your Honor.
Okay, thank you for your attendance and you are excused.
Thank you, Your Honor.
And you call your next witness.
Defense calls Michael Leonard.
State the evidence you'll give this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name, spell it for the record.
Michael Jonathan Leonard, MICHAELJONATHANLEONERD.
Okay. You may proceed.
Thank you. Mr. Leonard, what's your occupation?
I'm a corporate attorney.
And how long have you been an attorney doing corporate work?
It's just over 10 years.
And as part of your work, do you also do contract work?
I do.
In July of 2011, were you retained by an individual or by an entity to represent them in buying a business?
I was.
In what business were you involved in the purchase of?
I believe the name was Earth Inspired.
Let me ask you, did you draft a contract relating to that purchase?
I did.
In which showing you a copy of that contract, would that maybe refresh your memory of the name of the business?
It would. Written here, Earth Inspired Products.
And now you represented the buyer, the seller you did not represent, correct?
Correct.
And who was the seller of Earth Inspired Products in July of 2011?
Seller Daniel Kavanaugh.
And as part of your representation of the buyer, did you write up a contract for that transaction?
I did.
And as part of the contract, were there different detailed terms about the transaction that were listed within the contract?
There were.
And were there also general legal understandings between the parties that was drafted within the contract?
There were.
And did you draft that?
I did.
And looking at Exhibit 1058 in front of you, is that appear to be a copy of the contract that you kept as part of your records from that transaction?
It does.
And it shows a 200-page document with that seemed to be the entire document that was retained by you for purposes of documenting the transaction.
That sounds like the correct page number, yes.
And included in that sale were the rights to use Earth Inspired Products name?
To my memory, yes.
Any website they had?
They did have a website.
Any email addresses assigned or related to it?
I don't recall that off the top of my head, but probably yes.
And any other contracts or agreements you could have with outside vendors?
There probably were in that. I'm going off of memory, but there probably were, yes.
And as part of the consideration for the buyers of taking over this business, what was offered in return?
I believe there was an amount in cash and a percentage of the, whether it was gross or net now, I don't recall, but there was a percentage of the business ongoing after an initial cash payment.
And do you know the cash amount?
Going back 8 years of memory, I believe it was $20,000.
And do you remember the percentage of future earnings, the details of that?
I don't remember whether it was gross or net. I think I remember the number being around 20%.
If you were to look at page 40, I think 46 of that document, would that maybe help refresh your memory?
20% of net profit derived by the buyer.
And when this contract was drafted, what's your understanding of 20% of net profit? What does that generally mean?
That would mean for who my client was, which was a corporation, based upon their sales, there would be a gross sales amount, and then that would be less cost of goods sold. It would be cost of their overhead expenses, their employees, their shipping, whatever else, to the bottom end of perhaps before the owners of that business were paid. That would be the calculation of net profit.
So if I have a $10 shirt and it costs $5 to make and $2 to ship, that's $3 net profit.
Once you took care of your taxes and your
Taxes?
your lights, your rent, your insurance, and sure.
So you lost money.
And as part of the agreement, did the buyer also promise to assume any liabilities of the company as well?
They did.
And those liabilities were detailed out by the seller?
That sounds correct, yes. I'm not sure how the buyer would have known what the liabilities were.
Right? And as part of the sale, did Mr. Kavanaugh represent, as part of the transaction, that he was the sole proprietor of this business?
Objection, hearsay.
Overruled, can answer.
He did not verbally or basically in a writing to me. He was an opposing party to me, so he didn't communicate anything like that to me directly.
But was that the term of the contract, that he had to be the sole proprietor?
That's the way I drafted the contract, to protect my client, the buyer, yes.
You wouldn't want him to buy something that somebody else owns?
Hopefully not.
Right. And as part of the terms, it ought to have to be warranted. Well, there's the seller's warranty, right?
Yes.
Can you generally explain what a seller's warranty is?
That would just be to say that buyer is giving some amount of money and some further consideration, and if going through after taking over the business, we find that there's material issues, that there are things that weren't represented when the buyer's understanding to come in, that basically there will be consequences to the seller for things like that.
And as part of that warranty given by the seller, it was represented that the business was clear of any disputes or other ownership rights of other individuals?
That's what I would have written, yes.
Now, at the time this contract was drafted, did you do a due diligence to guarantee that everything that's within there, in the contract as represented by the seller, was accurate?
I did not.
And what date was this contract signed?
I'm sure you can tell me what page. It would be first or second week of July 2011.
I think it's the last page.
Okay.
If viewing that, would that maybe help refresh your memory?
That last page of...
Like the last 4 pages have all the...
Oh, okay. That would be July 9th, 2011.
And so if there were anything that came up as inaccurate in the contract's written as to allow for corrections or compensation or undoing a contract.
Corrections, rescissions, repayment of partial funds, it just depends on what was wrong with the business.
And so you wrote that into the contract to protect your client, the buyer, correct?
Correct.
And did the seller, Mr. Kavanaugh, have an attorney that you worked with during this transaction?
To my knowledge, he was unrepresented.
And I assume that you didn't give him any legal advice?
Certainly not.
And this contract was presented for him to review and read before he signed it?
Not by me. If it was, that would have gone through my client. Basically, I would have supplied them a copy of what I proposed. They would have sent to him.
And were you involved in any of the negotiations for the terms of the monetary terms?
I was not. My client gave me a set of terms, and I merely drafted the document according to the terms they gave me.
Did you ever have contact with any third parties who contacted you to contest this contract?
No.
Did you ever have any contact with law enforcement asking you about the details of this contract?
Objection, relevance.
Sustained.
Did anybody besides myself contact you about this contract?
Objection, relevance.
Sustained.
Okay. Can we be heard at sidebar on this line of question?
No.
Any of the liabilities that are contained within the contract, were you involved in documenting any of those for the contract?
I was not.
Did you have any conversations? Strike it. Did you ask for any documentation to verify the extent of the accuracy of those liabilities?
I did not.
Now, the liabilities that, as drafted, that would include that would include monetary debts, like if somebody owes somebody money.
Objection, speculation, relevance.
Overall, you can answer whether or not that was a subject of the either discussions or terms of the contract.
In the contract, if I understand the question, then the liabilities would include monetary amounts that were owed to third parties.
And would it also include liabilities for any possible or pending lawsuit?
That I don't recall, because normally when I would write an asset purchase agreement, I would write out that these are the actual liabilities, and then that would be handled in a different section where they were saying, other than as listed. And so if lawsuits were listed, maybe they would be included, but normally just a blanket saying, sure, whatever lawsuits are against this business, I'll just take over, would not be something I would normally write in an agreement.
Would reviewing page 49 of the contract maybe refresh your memory whether or not lawsuits were covered in part of the liability?
So looking at page 49, it appears that there are two listed, and so the listed ones.
Objection, hearsay.
Overall,
So it looks like there are two listed here, so it does not look like a blanket, just any lawsuit liability that exists is accepted. It looks like there were two and they're specified here as accepted liabilities by the buyer.
And looking on page 174, does that refresh your memory of whether or not some details of lawsuits were also contained within?
Objection, hearsay.
Not asking to go into the details of it.
overall, you can answer yes or no, or it refreshes the speculation.
Looking at page 174, appears to be a summons for a lawsuit.
And so there was documentation for some kind of, if there's any litigation pending.
Correct. There's a couple pages in here of that, it looks like.
what was the total consideration, not knowing future earnings, what was the total consideration that your clients took on for the purchase of this entity? Ballpark.
Ballpark, what did my clients pay for this? In cash up front, if I remember correctly, it was $20,000.
And with other absorption of liabilities, what was the ballpark understanding?
Objection, hearsay.
Sustained.
To the benefit of your client, is it the contract attempt to document the total cost to your client inside this contract?
If you mean the cost as the amount of cash paid plus the liabilities assumed, the answer would be yes.
Nothing further.
Hearing on cross?
Just briefly, so your sole role was to just draft the agreement for purchase and sale of assets, is that correct?
That's correct.
And you did nothing to verify any of the information that was provided to you in terms of the seller, is that correct?
On a transaction this size, that would be normal. My attorney's fees would have well exceeded the amount paid for it if we had to do a due diligence, correct?
Okay, and just to verify, none of this activity occurred with respect to that sale until July 9th of 2011, is that right?
What do you mean by activity around the sale?
Well, this agreement for purchase, none of that occurred until July 9th of 2011.
My client business would not have, the buyer would not have had possession of any part of the business until on or after July 9th.
Okay, nothing further, Your Honor.
Anything else?
No, Your Honor.
Mr. McGee, anything else?
Do you have any knowledge as to how long the negotiations for the purchase were going on?
I don't know how long they were talking before they engaged me. When I was engaged, I was actually paid a slight premium to write the contract over a 4th of July weekend. But so the buyer was in a bit of a hurry to take this business over. How long they had led up to that, I have no idea.
So it's fair to say your first contact was sometime after July 1st of 2011.
That sounds about right, yes.
Nothing further.
Anything else?
No, Your Honor.
Was there any time limit on the period of time that the seller would continue to receive approximately 20% of the net profit?
Let me take a look at that page, Your Honor. I don't remember that off the top of my head.
Page 45.
I do not see an end date to the payment of the 20% of net profit, so that looks like that was professional.
Okay, and did you ever meet with the seller or have any discussions with the seller?
The seller came to my office on what apparently was probably July 9th.
Just to sign something?
We did a closing at my desk, and so the representative of my client corporation were there, and the seller showed up to my office to do that.
And just basically, here's contract, you've reviewed it, signed it, end of story.
Yes, that was
Okay, very good. Anything else?
No, Your Honor.
1 second. Would reviewing page 5 maybe refresh your memory as to the judge's question?
Which particular question?
Length.
Okay. Well, it appears that the thank you. It appears that the promissory note on page 46 did not have an end date to it. It looks like section 2B of the agreement, the 20% payment was for a period of 12 months.
Okay.
So, sorry, 8 years ago I wrote it.
I understand. Okay. Anything else? Anything else?
No, Your Honor.
Any objection to Mr. Leonard being excused?
No, Your Honor.
Thank you, sir, for your attendance and your excuse.
Thank you, Your Honor.
And we'll call your next witness.
Yes, Your Honor. The next witness would be Randolph Beasley. We can start.
Yeah, that's what I was gonna suggest, we can go ahead and do, I know there's one area that council wanted to discuss, but if we can do the other areas, we can.
Correct.
That's fine.
Do you solemnly state evidence related to these matters the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. State your full name, spell it for the record.
Randolph Bruce Beasley, R-A-N-D-O-L-P-H, B-R-U-C-E, B-E-A-S-L-E-Y.
Okay, you may proceed.
Thank you. Mr. Beasley, what do you do for a living?
I'm a forensic consultant.
And when you say forensic consultant, what type of topics do you consult for?
I consult for things related to forensic science and crime scene investigation for both the prosecution and defense in civil and criminal court. That would be related to evidence processing, blood stain pattern analysis, crime scene reconstruction, and other forensic disciplines.
And did you have how long have you been consulting?
I'm sorry, say again?
How long have you been acting as a consultant?
Consultant, let's see, for teaching since 2001. When I retired from the crime lab, I was going to mainly focus on teaching, but they retained me on a civil case in 2010. So that would be kind of distinguishing those two, consulting for teaching versus consulting for crime scene and forensic evidence processing.
And as you mentioned, I was going to get to, at some point you used to work for a crime lab?
Yes.
What county?
San Bernardino County.
And what years or months and years did you work for San Bernardino County?
I started in 1977 and I retired in 2007, so just a little over 30 years. The last 19 of those years were in the crime scene investigation unit.
And in the crime scene investigation unit, as part of your duties involved responding to crime scenes?
Yes.
And those can be, you're there to assist the investigators?
Yes.
And what was your general duties when you'd respond to crime scenes when you worked for the crime lab?
My duties were related to kind of overall, the search and collection of physical evidence, photography, evidence collection, fingerprint processing, bloodstain pattern analysis, bullet trajectory determinations. So in our county, they let us get cross-trained in all of those areas, which is why I stayed for so long, actually.
And did you also get involved in crime scene reconstruction?
Yes.
And what does that mean?
Crime scene reconstruction is putting the pieces together from all of the evidence, all of the expert opinions, all of the analysis, and then putting that together to ideally make sense of what happened and what did not happen as it related to an incident that is being investigated.
So it'd be like you would show up at a scene, everybody says, I found this, I found this, I found this. You get with the detectives and say, this is what I'm seeing from a big picture.
Yes, and in our department in San Bernardino County, I would get with the assigned case agent, which is typically a detective who's assigned to work with the crime scene specialist to locate the evidence first. Step one is locate it. Step two is then document what potentially could be evidence, and then the collection part. So that step one of crime scene reconstruction is really gathering all of the evidence. It starts at the scene, but oftentimes it certainly doesn't and shouldn't end at the scene. After analysis, DNA, ballistics, fingerprinting, after all of that is accomplished, then step two in crime scene reconstruction is to evaluate that. And when you evaluate that, oftentimes you find that there is something else that could be done, and so you go back to step one, which could be that search for additional evidence or analysis that has not yet been done.
Okay, so I hate lawyer shows. I think they're CSI, they have a bunch of those, I don't watch them. Is that something that show, have you ever seen it before, any of the CSI shows?
Yes.
Does that kind of represent generally what you would do?
Generally, yes. They certainly are consistent in exaggerating things for Hollywood, you know, the sensationalness of it. So certain procedures are totally incorrect. I saw one episode where they had a garden sprayer, and they were spraying
Objection, relevance, McStay.
Overruled. Go ahead.
Not to go on and on, however, the spraying of a reagent that was phenolphthalein, I'll get the spelling to you later on that one, phenolphthalein, it's very hazardous, and you would never do that. But yet that's, whoever was advising them was not doing that correctly. My pet peeve though is Dexter, if I could just, Dexter.
We won't ask.
Okay.
You would also not only process crime scenes, but you'd also process vehicles?
Yes.
And what kind of process of vehicles would you perform?
I would perform whatever I thought would be needed or necessary. So it would start with a search for evidence, identifying evidence, possible evidence. I would then take photographs. I would be the one who would collect that evidence and then package it and submit it to the crime lab for additional analysis.
And this could be search for latent prints?
Yes.
Trace evidence?
Yes.
And actually, as you said, physical evidence?
Yes.
Sometimes would you have to document things about the tire treads?
Yes.
Do you ever attend autopsies to document findings during pathology exams?
Yes.
And what kind of things would you be involved in at an autopsy?
I would be involved in, number one, the photography, and number two, taking possession of evidence when the deputy, or the pathologist would make a collection. They would often have us do the clipping of fingernails sometimes, or at least just collect the clipping of fingernails. Could be on occasion taking impressions. If there is an impression on the body, that's something that I have done before. But primarily photography and evidence collection.
Were you ever involved in using trajectory rods?
Yes.
And what's a trajectory rod?
Objection, relevance.
Sustain.
Did you ever work in the laboratory to process items that were collected?
Yes.
And what kind of processing of evidence were you involved in during your time at the crime lab?
We would follow our own evidence, especially that we would collect in the scene, in the field rather, at a scene, and then process those items for fingerprints at the crime lab. That was done most often. So it would be whether it's a weapon, for swabbing for DNA, or processing for latent fingerprints, photography of those items. collecting trace evidence using tape lists from those items, and then submitting those items of evidence for additional analysis. We then rotated in the crime lab, having responsibilities for getting fingerprint cases from the law enforcement agencies within San Bernardino County. So they would turn in evidence just to be processed for fingerprints, sometimes for blood as well, although there was a separate unit in the lab for just blood. So oftentimes vehicles would be towed to the crime lab as well, and in our own garage we would process those vehicles.
Now, have you ever qualified as an expert witness in any court?
Yes.
And what courts have you qualified in as an expert?
If I could refer to my CD.
Would that help refresh your memory?
Yes. And I was working on updating this, by the way, so I have copies for both sides of that.
I was going to ask, I remembered you said you were going to bring copies for myself and opposing counsel. Do you have copies for us?
I do.
If I can collect those so counsel and I can follow along. Thank you.
So regarding court testimony, on page 9 of my CV, which is just like a professional resume, I testified in San Bernardino County Municipal Court and Superior Court, Riverside County, Superior Court, LA County, Ada County, Idaho, Broward County, Florida, and then U.S. Federal Court, Los Angeles, Riverside, San Diego, California, and then Omaha, Nebraska, and then I just last year testified in the U.S. military court in South Korea on a crime scene reconstruction case. So that's what was added.
Approximately how many times have you qualified and testified as an expert witness in court?
It's over 100. I don't have a more accurate number.
And what are some of the topics you have testified about in court before as a qualified expert?
Crime scene photography, crime scene evidence collection, crime scene processing, fingerprint processing, blood stain pattern analysis, crime scene reconstruction. That sounds about like it.
Bullet trajectory?
Bullet trajectory determinations.
Shoe print comparisons?
Yes, I have. That's not my forte, but I have qualified as an expert in that.
Tire impression comparison?
Yes.
And I think you already said evidence collection, correct?
Correct.
And evidence processing as well?
Yes.
Have you ever been certified by any associations relating to your field?
Yes.
And what certifications have you received at any time in your career?
I've received a crime scene analyst certification from the oldest forensic organization. It's called the International Association for Identification, and they've been around over 100 years. I've also been certified as a senior crime scene analyst with that organization, and also a blood stain pattern examiner. Those certifications were when I was employed with the Sheriff's Crime Lab.
And do you have any memberships in any associations relating to your current consulting?
Yes, I'm a lifetime member of the International Association for Identification.
And when you say lifetime member, is that given to everybody on the first day, or is that something that's earned?
You earn it because you pay your dues for like 20 years. Yes, you earn it.
So it's been over 20 years you were a regular member that became a lifetime member?
I believe so.
And have you received any training yourself on different issues to help you qualify as the expert as you testified to before?
Yes.
And okay, but I'll kind of take this over so you don't take too long. Have you been trained on bloodstain pattern identification?
Yes.
And documentation?
Yes.
Approximately how many hours have you had on that, would you ballpark? Over 150 sound right?
Probably.
How about fluorescein blood enhancement training?
Yes.
And what is that?
Fluorescein is a chemical reagent that will enhance latent blood stains so that they would fluoresce and then become visible to be documented. So it could potentially show if blood's been cleaned up, bloody shoe prints that aren't visible to the naked eye, that kind of evidence.
And also crime scene processing, trained on that?
Yes.
Latent print processing?
Yes.
Latent print examining?
Yes.
Forensic shooting scene reconstruction?
Yes.
And I'm going to skip the others. Now, do you actually train others?
Yes.
Let's start with your time at the Sheriff's Crime Lab in San Bernardino. What did you do for training at the crime lab?
At the crime lab, I was one of the instructors of the bloodstain pattern analysis portion of an advanced homicide investigation class. I also trained in crime scene photography and crime scene processing with new CSI trainees. It would be all of the above, assisting as a trainer for bullet trajectory determinations and crime scene reconstruction.
Were you also involved in giving a proficiency exam to other staff on subjects that you taught?
Yes.
And did you do any teaching or training outside the crime lab?
Yes, I have.
I'll try and help you out here. Did you do training on latent print processing?
Yes.
And that would be with the Sheriff's Training Center?
Correct.
For a number of years?
Yes.
Bloodstain pattern interpretation at an advanced homicide investigation?
Yes.
For a number of years?
Yes.
Obviously, crime scene processing, you taught on that?
Correct.
Number of years?
Yes.
Gunshot residue collection?
Yes.
Let's see. Identification, collection, and preservation of evidence?
Yes.
Number of years?
Yes.
Gunshot residue collection? I already had that twice, never mind. Let's see. Documentation of bloodstain pattern evidence workshop?
Yes.
And that was at the International Association of Identification?
Yes, the association that I'm a member of has requested that I do certain classes, and I offered to teach certain classes over the years, and I've done that.
And you've done that multiple times for that organization?
Yes.
And you've also done it for the California Association of Criminalists?
Yes.
And also for the Department of Justice?
Correct. Department of Justice Riverside office.
And you also did that for San Diego as well?
Correct. Our lab director and I taught outside of the crime lab, and twice we went down to San Diego County Sheriff and taught their criminalists and evidence technicians on bloodstain pattern documentation.
And you also taught one on fluorescein technique on latent bloodstain workshop?
Yes.
With the same International Association of Identification?
Correct.
In Nevada?
When was that?
2000?
I don't remember that one. Sorry.
I got it from your CV.
Okay, it's on my CV then.
Let's see. Crime scene processing and documentation as far as advanced homicide investigation?
Yes.
Photography and evidence collection?
Yes.
Again, bloodstain pattern analysis at the Riverside City College?
Yes.
And you did similar crime scene management, photography, bloodstain analysis at Desert Career College as well?
Yes.
And you did the same kind of blood pattern analysis for UC Riverside?
Yes. That was more of a lecture, but
And then you also involved in presentations on subjects as well?
Yes.
How are presentations different than teaching?
Teaching usually involves more of a hands-on potential, if it's in a workshop form, type of environment, where lecture is designed to also teach, but it's done in a lecture using a PowerPoint presentation, based on my experience in the field, is a good way to also educate someone in this field.
And you gave a few of these presentations recently, within the last 10 years, correct?
Yes.
Like one would be Crime Scene Reconstruction, and Another View from the Dark Side, presented to the California State Division of IAI Educational Conference.
Yes.
That was in May of 2016, correct?
Yes.
And then Crime Scene Reconstruction, A View from the Dark Side. That's in August of 2015. I guess that was the first one.
Correct.
And what were the kind of subjects we were talking about there in the presentation?
The subject there was something that's a reality within law enforcement and forensic science, where if someone, as I do now as a consultant, assists or consults for the defense, they call that the dark side. So it's the reality of trying to educate people within the forensic science community that there is not a dark side and then I guess a light side. There's only what the evidence shows. So my goal in those lectures is to basically be...
Objection, relevance, non-responsive.
...is to address the potential bias on both sides that in my experiences exists on both sides, so that a crime scene specialist or investigator focuses on the evidence and doesn't get locked into a certain mindset to help one side or the other.
You also did a similar presentation on the crime scene reconstruction. Sometimes it's what's missing that matters?
Correct.
What do you mean by that in your presentation?
That was related to evidence that could be missing that is important. So I want to educate crime scene people that don't always focus on what's there. Really take ownership of your duties to look at what isn't there, because that could be important as well.
And lastly, you did a wipe, swipe, and cast off training for the Rhodes Scholar Educational Seminar.
Yes, and that was related to different patterns of bloodstained patterns.
Now, at some point, you're retained on this case to assist and consult with the defense, correct?
Yes.
And as part of that, what information did you ask to see so you can look at to evaluate the case?
All the notes and reports and photographs.
Well, let's go through. You wanted all the initial photographs of the residents taken on February 15th of 2010 by the first responding officer?
Yes.
You wanted the crime scene photographs, reports, and notes relating to the search that was done on February 19th of 2010?
Yes.
And I believe Detective DeGaulle and Dennis Williams testified to that, and you were present during that testimony?
Yes.
You also wanted the reports and notes completed by the San Diego Sheriff's Department Crime Lab, Forensic Division for Ms. Williams and two criminalists, Chang and Castro?
Yes.
It'd obviously be helpful for you to watch testimony of all the people that testified from a crime scene analysis or collection standpoint, correct?
Correct.
Could you see all the testimony that you wanted to see in this trial that you thought was necessary?
Yes.
And in preparation for your final conclusions in this case, did you get involved in any experiments that you performed?
Objection, relevance.
Sustained.
And
At
did you
this time,
review?
sustained is overbroad.
Well, it was just a general yes and no at the.
And therefore it's overbroad.
Did you get involved in any experiments regarding blood stain analysis and photography evidence in this case?
Same objection.
Overruled, cancer.
Yes, I did.
And when did you do those?
Started March 13th, 2019, and continued into the end of March, I believe.
And as part of your process, you also like to familiarize yourself with other causes or possible effects of things that you'll see at a scene?
Yes.
Is that important in your line of work as an expert to kind of review documentation outside from other experts or other fields to help explain what you're seeing?
Yes, I think that's part of my role as a crime scene reconstructionist.
And did you look into some of that documentation in how furniture is treated?
Yes.
Objection, relevance.
How what is treated?
Furniture, like wood furniture is treated.
Overruled.
Yes, I did an investigation on how spatter.
Objection, non-responsive.
Overruled.
Yes, I did.
Your Honor, can we approach?
No.
Oh, okay.
Did an experiment, or actually checked into research of how furniture staining is done, specific to how a spatter effect becomes part of a furniture finish, like I noticed and observed on my own wood dining room table. And so I did some experiments about that.
All right, we'll get to that later. And in reviewing a lot of the pictures that were taken on February 19th, did you highlight some that you felt were important for what they do not show?
Yes.
And if I can have my overhead. And you looked at exhibits 11, 12, 13, and 14 as seen from February 15th?
Yes, I did.
And exhibits 15, 16, and 17 from February 15th?
Yes, I did.
Now you thought for the search from February 19th, these exhibits 22, 23, and 24 were important to look at?
Yes.
And you also looked at 25, 26, 27?
Yes.
28, 29, and 30?
Yes.
31, 32, and 33?
Yes.
35, 39, 42?
Yes.
672 and 673?
Yes.
And in the garage, some of them were exhibit 74A, 75, and 83?
Yes.
Now looking at just not these pictures but other ones, did you notice that some of the things you were not seeing in these photographs?
Yes.
And please describe for the jury some of the things that you're not seeing that you would look for.
Blood evidence, and specific to really any kind of blood pattern, white stains, swipe stains, impact patterns, which we'll talk more later about, I believe, along with drip stains and a drip trail to indicate that either someone was bleeding at a scene or someone had suffered a blunt force trauma within the house somewhere. I did not observe any of that type of blood.
Did you see any damage to any of the walls?
No.
To the doors?
No.
To the windows?
No.
Flooring?
No.
Anything in the surfaces that were consistent in your experience of major blunt force trauma?
No.
anything in that house stand out as a clear indication of extensive violence occurring in that home?
No.
And you talked about different type of blood evidence. You said drip stains. What's a drip stain?
Drip stain is a stain that, maybe if I could read the definition to be consistent, then in my report, or...
If that helped be consistent, if you can read it from your report?
Yes, the association wants us to be consistent in our definitions. It's a big thing at the conference I just returned from.
With the court's permission?
Sure.
Okay. I guess I should have had my report right in front of me before I suggested that, right?
Your Honor, the clock on my computer was off. Does the court want to take a break
I'm
now, or
sorry?
you just want to skip a break for the morning?
Well, we started a little late, I was thinking maybe we'd go till about 11:40 and then just take our new recess.
That's fine. Okay.
Is that all right with everyone? Well, that's a long lunch.
I may have my report actually with my other things in my notebook, so let me just say, if you have it there.
If I read to you from your report, how's that?
That'll work.
Drip stains, a blood stain resulting from a falling drop that formed due to gravity.
Yes.
And you also mentioned drip trail, that be a blood stain pattern resulting from a movement of a source of a drip stain between 2 points.
Yes.
And a drip trail may be created on the floor or ground when a blood stained body, whether dead or alive, is transported between 2 points.
Yes.
So that's something to where if you're carrying something, stuff's leaving multiple drips showing, hey, there's a blood trail.
Correct. When there's a supply of blood, the stains will be circular, typically, and they'll be larger, and they will go in the direction of the person that is either bleeding or the direction of a blood source that is dripping onto the floor or ground.
You did not mention, how about transfer stains? Is that a term you're familiar with?
Yes.
And that's a blood stain resulting from contact between a blood-bearing surface and another surface?
Correct.
And what's an example of that?
So for example, if I have blood on my hands and I pick up any object, whether it is this beverage container here, if blood is wet, it will transfer from my hand onto the handle or anywhere else I touch, so that it would then be visible based on the amount of blood. Same would be for if I step into a pool of blood and then walk across carpet, flooring, blood will be transferred from my bloody sole of my shoe onto whatever surface I'm walking on. Again, as long as the blood is liquid and has not yet dried. So that would be a transfer from one surface to the other.
And then there's such thing as a swipe pattern you mentioned?
Yes, a swipe pattern is similar to a transfer pattern, except that it involves motion or movement. So if I have blood on my hand, if I have my blood on my clothing, and if I come in contact by brushing against a wall, a door jamb, any other surface, there's a swipe pattern that would show a movement, kind of like with a paintbrush. If you dip your brush into paint, and then you can sometimes see the direction of the movement as the feathered edge on a surface, similar with blood. And that would be a swipe pattern definition.
Jackson, can we turn the lights looking at exhibits 7.4A, 7.5, and 8.3 that are still up in the garage, did you see any kind of swipe pattern or transfer stain or drip trails inside the garage?
I did not.
Is that something you would expect to see if, let's just say, a corpse that was bloody was brought through that type quarters?
Objection, seems facts not in evidence.
Overruled.
I would expect the potential for that. Obviously, every situation's different, but if there's a body that's bleeding, any item that has blood on it, even if it's not an active bleeding, unless it's totally wrapped in plastic, for example, where it wouldn't leak through, then you wouldn't see it. But otherwise, you have the potential to see that blood trail.
And you didn't see that in anywhere in the house, correct?
Correct.
And then you also talked about, let's see, impact patterns. Impact pattern, I think you defined as a blood stain pattern resulting from an object striking liquid blood?
Yes.
And could you describe what that definition means? Or
An impact pattern is a pattern that would indicate that some force, as the definition states, is applied to a liquid blood. Typically, liquid blood would be someone's wound. It would take at least one injury to cause blood to be on the surface, a minimum of one. And so the second and then third and subsequent impacts or blows to someone's head, let's say, could cause an impact pattern, which would be a pattern of very small stains, typically 1 to 3 millimeters in size. And the impact pattern is something that would be deposited on a surface. Could be a wall, could be furniture, could just be the floor. And those series of small stains would have the potential of determining an area of origin when it's analyzed of where the individual was or the source of blood at the time that source was struck by some type of an object or a weapon.
and you also defined spatter stains. How's that different from an impact pattern?
A pattern is where it communicates together. In other words, you can associate an impact pattern where, as opposed to just individual stains. When you have a pattern, it's consistent with one or more impacts, so that the directionality of stains can help determine where let's say the victim was when they were struck, or the object was. So directionality is a term that is used to show the direction of travel for individual stains. And they're very elongated and very, very unique in that way.
And I believe you're going to do a demonstration after lunch on how that all works, correct?
Correct.
And then there's also something you defined, you haven't said yet, was a cast-off pattern.
Yes.
Are you familiar with that term?
Yes.
What is a cast-off pattern?
A cast-off pattern is a pattern of blood where the small stains are linear, or in other words, in a line. So blood that's on a weapon, for example, even if I have my pen as even an object, if it's dipped in blood, and if I raise my arm up like I'm going to stab someone with my pen, as I raise my arm up, the change of direction of my arm causes the blood to be flung in a linear pattern. That helps position where I was at the time, or actually the weapon, when it was used in that type of a motion. And there's a much shorter, simpler definition in my report.
Yes. Can we approach 1 second, Aaron?
Sure. With the recorder.
Sure. It does, not really. It's just a question about how to proceed, how the court wants me to proceed.
We should have the report.
Okay.
Okay, you can proceed.
Thank you. Now, did you review the testimony of Dr. Changsri about the autopsy performed in this case?
Yes, I did for part of it. I don't think I reviewed her entire testimony.
Did you review the autopsy protocol?
The autopsy reports, yes.
And then you reviewed these exhibits 779, 784, and 787, where Dr. Changsri detailed the injuries she determined were suffered by each victim that she can identify.
That does look like what I was referenced, yes.
And for refresher, 779 was for Joseph McStay. You can see his name listed at the bottom.
Yes.
And she highlighted where she thought the 4 impacts were on Joseph McStay's skull.
Yes.
Exhibit 784 was identified for Summer McStay, and she identified where she believes 6 impacts came in contact with Summer McStay's head and skull.
Yes.
And 787 was for Gianni McStay, and she identified where the 6 impacts occurred on Gianni McStay's skull.
Yes.
And Dr. Changsri said that she expect a large amount of blood to result from such injuries.
Objection vague. Misstates the evidence.
Now, in your 30 plus years of experience as a crime scene expert, have you ever gone to crime scenes for homicides occurred?
Yes.
Probably how many times?
I believe over 300 homicides, I believe. And that was in my the last 19 years that I was in CSI.
And of those, did any of those involve head injuries?
Yes.
Were you ever involved or present when the coroner became involved in removing the body?
Yes.
And do you know the purpose, or do you know the function that each individual serves at a crime scene? Like the crime scene specialist would be there to document evidence.
Correct.
The detective would be there to lead the investigation.
Correct.
What's the purpose of the coroner?
Coroner is to determine, number one, remove the body and determine the cause of death, if possible. So they take possession of the victim's body, and that's their function.
So if there's evidence at the scene, it's the crime scene specialist that picks it up. But the decedent themselves, nobody could touch but the coroner. Is that fair to say?
Yes.
Have you been present when the coroner has removed decedents from a scene?
Yes.
And when they do, how do they generally do it?
Generally, the body is placed in a body bag, and then the body bag is picked up and put on a gurney if the environment allows for a gurney to be in that location, and then the gurney is used to transport the body to the vehicle, typically a van. Bless you. So if the gurney can't actually be there, then the body is carried based on how heavy by grabbing the body bag and then transporting the body in that manner.
And after the body is removed, you then again process the scene after the decedent has been removed.
Correct. There could be evidence under the body, as an example.
And blood evidence could be found sometimes under the body, depending on the injuries.
Yes, blood evidence and any really type of evidence. Could be even a weapon under the body.
So In relation to Joseph McStay, Summer McStay, and Gianni McStay, who Dr. Changshri can detail the injuries suffered, do you have an opinion as to what kind of blood evidence you would expect to see at the places where these bodies came in contact with after suffering some of these injuries?
Objection, Locke's Foundation.
Calls for speculation as well.
Sustained lack of foundation. It's more of a medical issue which was addressed by the pathologist.
When a body suffers these type of injuries that you've documented, do you see blood evidence?
Usually, yes.
And what kind of blood evidence would you expect to see?
Objection, vague. Relevance.
Sustained on the same grounds and vague.
Would you expect to see a pool of blood somewhere on the scene?
Objection, Black's Foundation calls for speculation.
Sustained as Locke's Foundation and incomplete hypothetical.
If a decedent's head is destroyed, I think the testimony was, would you expect to find blood that you can then analyze and interpret?
Objection, Black's Foundation, and still an incomplete hypothetical.
I still can't hear you.
And still an incomplete hypothetical.
Sustained on both grounds.
Okay, so if an individual is struck in the head 6 times, their skull is destroyed, is broken down into little small pieces, and their blood pooling would be extensive after suffering such injury. Would you expect that blood pooling to be left at the scene after the body was removed?
Same objection, Locke's Foundation, incomplete hypothetical.
That's the exact testimony.
And assumes facts not evidence.
Again, the objection sustained, I think all of these issues were addressed by the pathologist.
Right, but this information is necessary for his further conclusions of what he sees from that blood evidence. This is all foundational for where he will testify later.
The objection still sustained.
So if an individual is struck in the skull, which would, in the skull, injuries would cause lacerations and blood loss, and someone is struck in the head again with the same item, same object, would blood spatter result from the secondary or consecutive strikes?
Same objections, incomplete hypothetical.
Yes. The first blow that causes a laceration would then result in blood on the surface of that person's head. The second, third, fourth, and fifth impacts, I would expect to see impact patterns. As long as it's close enough to a wall, it will be on the wall, or furniture. If it's in the middle of the room, it may only be on the floor. But it will, I would expect it to go several feet based on the object used and the severity of the laceration.
Would you also expect cast-off spatter?
Cast-off is possible. So I would certainly expect it, but it doesn't always occur.
And where would you generally look for cast-off blood evidence?
I look for cast-off on items of furniture, on walls, and even on the ceiling, because I've found cast-off stains on all of those surfaces.
And And if an individual suffered the injuries as I described, would you, if they were moved after suffering those injuries, would you expect to see things like the drip trails?
Yes, I would.
Would you expect to see, if they ever came to rest somewhere else, possible secondary pools?
Yes.
If while moving the body come in contact with any object, would you expect to see swipe patterns?
Objection, speculation, assumes facts not in evidence.
Overruled.
Yes, I would expect to see that if there's contact.
And if the bodies were bleeding extensively from head wounds and they're placed inside a vehicle, would you expect to see blood transfer inside the vehicle?
Objection, Knox Foundation, calls for
Overruled.
speculation.
Yes, I would.
And if there's any blood on the ground from the location where these assaults occurred, could you see the transfer of any blood by the assailant's feet?
So someone stepping into blood on the ground?
Yes.
Yes, it could then be transferred to wherever that person walked or made contact with any other surface with his shoes.
So if somebody walks through a pool of blood and walks, you'll have bloody footprints.
Correct.
Or if they walk through blood and then kick open a door, there might be blood transfer from the shoe to the door.
Objection, speculation, assumes facts not in evidence.
Overruled.
Correct.
If they walk through blood and get into a vehicle, you might find and drive.
I'm sorry, say again?
If you walk through blood and get into a vehicle and drive, you might find evidence of that blood inside the vehicle.
Yes.
And if someone has blood on their person from spatter or transfer or anything, and they get inside a vehicle, could you also look for that in different locations?
Yes.
And where would you expect to find blood in a vehicle if you were to look for it, if you were working under the assumption that an assailant might have blood on him?
Objection, vague, incomplete hypothetical, calls for speculation.
Overruled.
I would expect to find blood potentially anywhere the person that had blood on their clothing would make contact. So the door handles, the door panels, the floorboard area, the seat, any type of gear shift, steering wheel, of course, if they're the driver. Any place where there's blood, it can be transferred to any object that is touched in the operation of that motor vehicle.
In the seat, you just look on the flat areas, or is there different parts of the seat you may look at?
You would look everywhere. Oftentimes, for example, if there's an assault where blood is being shed, blood can go airborne. It does go airborne, and as the blood is spattered, blood goes up and oftentimes lands on the back clothing area of the individual who is making the assault. If there's then contact with that clothing on the back of the seat, would transfer blood if it was still wet.
This is probably a good time to stop here.
Okay, we'll go ahead and take our morning recess, this is a noon recess. And council had one area that you wanted to have hearing on.
Yes.
So we'll have our jurors come back at 2 o'clock, and then council can address the issue they want to address and won't keep you waiting. So we'll see everyone back at 2 o'clock. Keep in mind the admonitions not to form or express any opinions about the case, not to discuss the case, and we'll see everyone back at 2.